You're welcome back. This is Newsfile. It's your most authoritative news analysis show. My guests, Kweku Bako, Kofi Adams, Ernesta Bochi, and Clara Berry, Kasati. Now, we go to the office of the Special Prosecutor, the office that was quickly put together in record time with a law that is so progressive among all your anti-corruption laws in this country. A law that includes for him to exercise nolle prosequi and explain, because he shouldn't exercise it without explaining, among other things. So far, how good has he done? After a year, in January, he got announced. He went to Parliament in February. He got approved by Parliament, and then quickly the president inaugurated him with sufficient trust in him. I'm talking about Martin Amidu. Then, sometime in July, then the board of the Special Prosecutor was set up. And after it was set up, the president's confidence was even boosted further. And he said the office of the Special Prosecutor is now fully functional. Here we are. So far, as we know, only one case has made it to court from that office. And that case, for some, doesn't even seem a serious matter. Some actually believe he's pursuing petty stuff that other entities should take care of, and that his job is also being duplicated by the CID. Let's listen to Kojo Asante of the CDD, and then Linda Ofori-Kwafo, who is the chairperson of the board of the OSP.
In both the Metro case and the Galamsey cases, in the Metro Mass case, the complainant who took the case to the OSP ended up being investigated and prosecuted by the CID. In the Galamsey case, although Anas had announced that he had submitted the case to the OSP, the CID opened the case on the same matter upon the instructions of the Minister for Interior. Apart from the obvious duplication and the waste of resources, it can only encourage forum shopping on the part of suspects. At 959, it's clear that corruption and corruption-related offenses are the preserve of the OSP. These offenses included, listed in the Criminal Offences Act of 1960, the procurement offenses and related offenses to these two categories. During the parliamentary committee deliberations, there was an effort to insert a takeover clause allowing the OSP the power to take over corruption cases started by other agencies if it so wished. This was to affirm its jurisdiction. The only reference to this jurisdiction was expressed in Section 81 under transitional proceedings, where the AG could exercise her discretion to pass on cases handled by other agencies to the OSP.
You're welcome back. I'm sorry we didn't play you that of the chairperson of the OSP, Linda Ofori-Kwafo, but she has also been giving some assurances that the office will open up a lot more, particularly pursuant to Section 3 of the Act, which requires that quarterly they publish matters that are being investigated, the matters that it has worked on, and the status of those cases. Okay, so Clara, start with you, because we know the CDD and its other anti-corruption partners put together this program that was organized in the course of the week to try and, examine, assess the work of the OSP a year on. And because of your associating with the CDD, let me ask you, are you disappointed, like many others who say they are disappointed with the OSP?
My comments on this show are my personal views, so they should not be associated, yes. Now, am I disappointed? I'm actually, I can't say I'm disappointed or not disappointed. I'm actually having a difficulty in answering that yes or no, because as I said, I have concerns, I would say, but am I impressed? No, I'm not impressed. But am I disappointed? I think there are some issues that we need to look at. I think there are some things that we need to consider and some things that we can do. But I wouldn't say straightforward that I am disappointed, although I am not impressed either. Yes.
Okay. The CDD actually has said officially that, you know, he's been slow. And sorry when we say he, because the office literally is around an individual.
Yeah.
So he's been slow, but he can't be blamed. And some of the reasons are what you heard Dr. Kuja Asante speak about. Kofi Bentel of Imani says Martin Amidu has done poorly, disappointing. And Imani Africa's Franklin Kujo also says it's not surprising that Martin Amidu hasn't made any prosecution. He believes that he ought to be given what he deserves to be able to do his work. For him, the OSP needs not less than 25 committed investigators who should be well-resourced, such that no person can lure them, just as it happened in Brazil, leading to the incarceration of even a former president. So things are not happening.
Yes, things are not happening. But for me, I come back to broader issues. We seem to have this penchant that when we have a problem and then we talk about it, once we pass a law, then we create an office, then we appoint people onto that office, we have dealt with the problem. Then although we have not touched the problem, we now play the ostrich with the problem and convince ourselves that we have dealt with the problem, and then we move on to the next issue. It's not just the OSP. It's a consistent problem. I mean, a lot of institutions that we have set up. The resource issue is always endemic. And I don't know why we do not kind of learn from what has happened so that we do anything. Yes, it is true that from all the reports that we are getting, resource is an issue. Litigation requires a lot of resources. I think as for the expertise, the OSP has the expertise. This is someone who has practiced in the courts for several years. And we know that for every profession, it is practice that makes perfect. So I don't think there are any issues when it comes to his expertise or his capability. I think he has the expertise. He can actually train because he has practiced where he should get his training from, which is the courts.
They say the path of the law is experience.
Yes, and he has, there's no doubt that he has the experience. But we know that a lot more goes into litigation. It's not just what you see in court. It's actually what happens before you get to court. And before you get your case correct, you must have done your investigations, assembled your evidence, assembled your witnesses, you know which witnesses you're calling, and then you proceed to the courts. The issue is what resources do they have? The issue is the collaborations. We are carrying out some research. In due time, we'll come out with that research. But part of the recommendations is the collaborations between state agencies. All state agencies have a common mandate. All state agencies have a common objective. And that objective is for the wealth, to work in the interest of the people, for the welfare of the people. Now, what kind of collaborations do we have? We must begin to, even where the issues, I always say, where you think there are gray areas or any particular issue straddles more than one institution, there is no reason why there cannot be collaboration between the relevant institutions. And then the institutions decide who is best to handle this matter. So, for example, resources. If the OSP doesn't have a resource, we know that there are some of the issues that fall not just in the OSP's jurisdiction, they fall also in the jurisdiction of IOCO, for example, and then other state institutions. How are they working together? But I think the OSP more than anybody knows that the faith, the Ghanaian public, I don't know that anybody has gained so much public endorsements with respect to their appointment as the OSP has.
Right.
There was a lot of hope. And then he knows that people put a lot of hope in his office. We just hope that, one, they comply with the legal requirement that they should publish reports biannually, so it will be twice a month. So they will keep the timeline so that they inform the Ghanaian public as to what is going on. And hopefully we don't have, should I say, leaked. I was not very happy when I saw the list that we have, because the law is clear as to what reports they can give. And the law is clear as to the timelines to give to those reports. The OSP needs to maintain the public confidence and just needs to keep in accordance with the law so that they do not get quite distracted when it comes to the issue. It's difficult. It's difficult, but we are hoping that very soon we are going to have officially, in accordance with Section 3 of the OSP Act, that we would come up with the report so that we know what is happening. But I am sure the OSP also knows that Ghanaians are fast becoming disenchanted. So the office does need to do a lot more work on it. And our excuses shouldn't, I think everybody's getting tired of excuses. I think so.
Okay, so Kweku, the NDC's charge has been that the OSP has been talking more than he has to work. For some time now, he's not actually, spoken as he used to do, write his epistles. He hasn't done that yet. Are you as disappointed as the sections of Ghanaians who are?
No, I'm not disappointed. I'm very patient and very optimistic. This is an office that was created less than 2 years ago. Look, this is a new creature. And there was the reason why we all went along supporting this creature. Over the years, we've been talking about how attorney generals find it difficult to prosecute people of their own, from their own camp. There were those who were agitating for decoupling the Ministry of Justice from the Attorney General, even though that really didn't need a constitutional amendment to effect. At the end of the day, the MPP in its manifesto pledged to create this special or specialized office to fight corruption. The philosophy, the motivation and things behind it, I think were commendable, and I'm totally for it. Thankfully, when it came to the legislature's turn to deal with the matter, in spite of all the early controversies and suspicions and things, they unanimously dealt with the issue. Indeed, most of the amendments even came from the minority side.
Right.
And then when he was nominated and appointed, there was also a consensus. They approved him. It's too early for us to judge if we are looking into the future. This is not an office that was created. There are some people who are agitating. They think that, oh, come on, they want to see their political opponents or perceived, business opponents dealt with. They are in a hurry. Some are from the ruling party. Some are holding press conferences and things and insisting that the office should move and do something.
Anti-corruption campaigners like Vitus Azim says the state can do better than it has done, because it's not just about voting 180 million in the budget for it, even though the finance minister had even promised that beyond the budget that they have made for him, they would also advance some monies as and when it's necessary.
Step by step.
So how can we use resources as an excuse?
It's not resources. It's the beginning, step by step. They even needed an accommodation, a good accommodation. I know where they're operating now.
So the question is that if we are that serious about it, and if we give it the priority that we seem to give indications about, must it take this long?
No, wait. Then you're asking a different question from what I was addressing. Whether the executive has provided sufficient resources timely, it's another matter. And we all know the drill we went through. But gradually those issues have been dealt with. It's a fact. Those issues have been, they've identified a place, quite an imposing place. It's been put in order for the office to relocate. Right now they are somewhere Labone near the coffee shop. I've been there to see the place. It's not the best of places, but obviously there's a decision in agreement with the office to relocate. Some budgetary allocation has been made. there's a commitment. People are looking for fast track, looking for speed. I'm saying that we should take our time. This is an office that is meant to be here for a very, very long time, if not forever.
Efficiency includes speed.
Be careful. They say justice hurried is justice buried. I've heard that said by some jurists and things. I have patience. I'm not saying that we shouldn't look at those issues that have caused delay or are creating difficulties. No, in looking at them, criticizing them, or recommending solutions will help. So I'm not for one moment excluding the challenges that have bedeviled the office. Anybody who raised, the officer himself, the special prosecutor himself raised some not too long ago at a public forum, together with the Auditor General. Of course, there were aspects of things that he raised that my own checks thought were a bit over the bar. Okay, he's also complained about lack of cooperation from some members of government.
The government, yeah.
My checks on those things, I realized basically it is to do with the UO group docket, the police docket that he's seeking, and which appears to be missing in action. And that's not unusual, as far as I know, in our legal system. Mr. Buchi and Clara, you would know that dockets that get missing and eventually reappear or so. But you see, I've checked all the correspondence on that matter, and that was where his beef was. Even though the Attorney General's office was cooperating with him to locate the docket, they found some aspects of the docket, but not the docket itself. These are, for me, transitional challenges. That's the way I see it. Because the faith that we've put in that office should be deep-rooted.
The EO group matter he complained about, in the OSP's list of cases that it is either investigating or is interested in, and so on, about 26 cases that we have become aware of. Joy News through Kojo Yankson got an exclusive of, is the matter listed number 12, and it's about using public office for private benefit, diversion of 13 million United States dollars EO group money. And the subject apparently under investigation or to be investigated, or the interested party, is President Mahama. And the status of that case is case yet to be assigned for investigation.
Yeah, you see.
What do you say to those who raise the question that these kinds of cases, they don't appear to be things of any substance that a serious office like his should waste his time on? You should pursue the things that are clear, that people know, and they are asking for immediate action.
Well, perhaps because of my personal knowledge about this EU thing and the path being pursued, my answer is that yes, this EU thing has no merit. But it is not for me to judge. Some people have petitioned the office. Indeed, I've said it elsewhere. Those who petitioned, if they were so minded, maybe should have gone elsewhere. Because even in the petition, their source is the special prosecutor and things he wrote earlier. And so it presents a certain challenge for even the special prosecutor himself. I would have gone to Yuko and the rest, but truly speaking, that case has no merit. But that doesn't mean it cannot be investigated. Indeed, it should be investigated to prove the lack of merit.
Okay.
In the kind of democracy we have. If you were to ignore it and throw it into the dustbin, which I would have done, but for an office of that nature, investigate it, let everybody see, there's absolutely nothing there.
On the basis of your faith and hope, how soon are you expecting that something concrete will happen, as in, prosecution?
See, his work, there are some things going on. For instance, the Anas Galamsey part 1, fraud part 1, is being investigated.
Right.
I'm aware that Anas and his group have been there. Charles Bisu and is it Andy something? They've been there.
Right.
They've been interrogated. They are setting up something. depending on how things go, it may or may not go to court. I'm not the one to take that decision. But I'm aware there's something happening. You also indicated there's a case in court,
right?
Which I'm not sure. I don't know which case is in court.
Yeah, there's one in court. I'll point to it. Yeah.
And that list which the chairperson is asking us to, ignore. My information is that list is an authentic list.
Thank you. Thank you. So there's a list of 26 cases pending investigation, some being investigated, people who have been interrogated and granted bail by the special prosecutor, and one of them that is currently in court, and then a good number of them that are cases that it is interested in but has not done anything about them yet, that have been put out there. And you heard the chairperson of the board speaking to the graphic that it might not be authentic.
It was intercepted.
Yeah.
Or leaked, or both.
And that was put out actually by Kojo Yang saying through the multimedia platform. Kwekubako is saying that his sources is that this is authentic. I'll come to Abochi subsequently and find out whether or not it may be fair to be interested in cases, to be investigating cases, and be publishing them, so to speak, whether the law allows that to happen. But the NDC is clear that this was sort of a strategy by the administration, Akufo-Addo administration, but the OSP didn't know, and he has played into a certain strategy. Set up the office, put somebody in there, but don't resource them to do the work in the name of you are fighting corruption. That's what the NDC is saying. In fact, you have gone ahead to suggest that immediately you get the opportunity in office, his office will be collapsed and he will lose his job.
Thompson, thank you. I'm not aware of office being collapsed.
That's what Otokono says. You know who Otokono is, right?
Losing of job matter. But it is very clear that when people say that the special prosecutor fell into the game of this government, clearly the people will be right in saying so. What was the problem that was confronting us as a country? Maybe until under President Mahama, where we had a few cases involving his appointees being subjected to prosecution, and some of them resulting in sentences happening even though later. We really did not experience much of your own Attorney General taking you to court. So the position was to create an office such as this, where the burden on an Attorney General who normally happens to be a party member having difficulties taking cases happening fresh under a government that or a party that is in government to courts. Because if it is about prosecuting your political opponents, the Attorney General is rightly there, the CID is still there, and so on and so forth, to continue the performance of its duty. So one is therefore worried when you have the communication director of MPP venting his anger on the office of the special prosecutor instead of the Attorney General and Minister for Justice, who was long appointed and who has better structures in place even before this special prosecutor was recommended for appointment, or even the bill was developed, sent to Parliament, approved, and then the appointment of the person and to be vetted and so on and so forth. Before then, you had an Attorney General who has budgetary allocations and what have you. They are not interested in taking on that person for no prosecution. There are no prosecutions because the cases you think that you want prosecuted can really not be prosecuted. There is nothing there. Like Kweku said, that some of the listed cases, even under the office of the special prosecutor that they are looking into, some of them are even non-starters. But because there is a petitioner, you can't also say that you would not look into it. But like he's right when he says that the petitioners were referencing lawyer Martin Amido himself, who is the special prosecutor now. They were referencing him based on his articles that he wrote. Some of these articles he wrote, he was asked questions about it when he appeared before the appointments committee. And what did he say? He says, oh, there was really no evidence to what he was writing, but it is more of perception and so on and so forth. So clearly, to base your petition on a source, on a person who himself has admitted before the appointments committee that it was based on perception, not like he had facts, not like he had any evidence when he was writing those things, should tell you that you really are on some kind of expedition that will take you nowhere. But I'm clearly so worried that an office that we expect all to have so much confidence in will be engaging in leaks such as they have done.
No, you can't say that.
Leaks.
Of course, the information that has come out hasn't come out officially.
The journalists are doing their work.
The leak.
And the journalists are doing their work.
How did the journalists get the information?
So many
is it not through somebody giving it?
Yeah,
No,
but not the office.
not always.
You are saying
No.
the office.
I'm saying that.
Your
I'm saying
emphasis.
that. No, the office that we all have so much confidence in will have people who will leak.
But even BNI documents leak.
I'm saying that. I'm saying that. The
Defense
office,
intelligence
the
documents
office that we all are thinking that it will be used appropriately, will have people leak such cases, especially that have not even been assigned an investigator. A case.
Don't worry yourself about
A
that.
case that have not even been assigned an investigator. But you see, I don't know how you lawyers describe it, as if it's particulars of the case. Oh, maybe act of corruption. The act is this. And then you put it out there. Social media starts discussing it. And you are judged by social media
blame us,
even
the
before, no.
Blame the media or the social media team.
The media,
Okay, thank you.
The media is looking for information. If you give the information to the media, they will put it out there. They won't protect it for you. The person surely gave it from the.
Which person?
Why was the case? Was those cases listed by your office?
Well,
was it listed by
not
the?
Kojo
By the
Jansen or Joy
by
FM
the-
have told you that this was leaked to them.
I'm saying that.
Right. Thank you.
Whatever it is, that information is coming from the office,
Okay.
that office. They would have put those things together. An individual in the office would have done so. I'm not saying that the
Okay,
office
so don't belabor that
officially-
point. Don't belabor that
No,
point. Why
Samson.
do you think this office
Samson,
will not
the
amount?
reason why
This office will not amount to
the
much?
reason why I will be worried is that you remember when a director of communication of a ruling party comes out to start putting pressure on the special prosecutor that you must work, and the next thing we see is these publications of cases that even have not been assigned investigators, cases that we know that even the special prosecutor himself, when he appeared before the appointments committee, made comments to the effect that, look, he had actually no evidence when he wrote the things that he wrote on such persons. We need to be worried. And it must not be used as a political witch hunt agency. And all of us must state so clearly. Where you put it out, then it is being discussed. It's been thrown out there. Oh, the former president is being investigated. This one is being investigated. This case has not been assigned. This one was engaged in this act. For me, is clearly and clearly wrong. And
but the cases cut across. It's not only former officers.
Yeah.
Oh, of course.
Even people in the present government have also been named in there. Anyway, thank you.
That's true. That the chairman
Right.
of the party has been named, but of course that matter.
I think there was a name of a minister. too
That
somewhere.
matter,
Yes.
that matter for which they have referred to the office of the special prosecutor have been reported to the Shraj, which is looking into the matter. And recently, I saw publications that they want to even cite the MPP chairman for contempt for refusing to either respond to invitations or supply information that Shraj needs to pursue that matter. Whether a matter that has been reported to Shraj needs to be reported to the office of the special prosecutor again for another investigation is yet a matter that we all have to.
Thank you. Let's
hear.
hear from Mr. Bochi and the list that Joy intercepted and has published. I just mentioned a few of the cases listed in there for you. Case 1, they state the place, either Accra, Kumasi, or wherever, and then they also indicate the specific offense or matter that they are looking at, and then they give you the status. Number 1, Boku, procurement breach, ambulance, Boku Municipal Assembly and Health Directorate, who are the persons being investigated. Mahama, Ayarga, and then 6 others. Then they say case is under investigations. Accra, suspected misappropriation of public funds, and ML, properties in Ghana and South Africa. They name Nana Oyelita, statement taken from respondents. Of course, you have heard Nana Oyelita say, I'll have my day in court, but this is a bogus matter. Accra, again, misappropriation of public funds and money laundering. Purchase of 275 buses. Freddie Blay. Case yet to be assigned for investigations. Number 4, Accra, suspected breach of procurement processes. AMA Millennium School Project. Mr. Sam Aye Date, Metropolitan Coordinating Director. Investigation ongoing. Documents produced by Mayor on request by the SP. 5, Accra, abuse of public office. Agric mechanization, all right, and former and current MPs. So that one, a number of MPs involved. Documents produced by the Ministry of Finance. Ministry of Finance. Then 6, Boku, back to Boku, tax evasion. They say Mahama Yarga, case ongoing. Respondent yet to be invited. Accra suspected misappropriation of public funds, diversion of project funds to finance NDC party research. Rojo Metal Nunu, statement obtained from broadcast journalist Kwete Nate. Then 8, Accra, abuse of public office. Okay, abuse of public office. It's just a naming of the thing, but you will not have that as a crime so stated in the law. Mahama Yarga, again, they mentioned Kojo Opon Nkrumah and 8 others. Caution statements obtained from respondents, except Honorable Mahama Yarga and Honorable Kwabena Pinkra. So it continues, it gets to the EO group matter that I mentioned, and then a very last one, let me share. Wa Upper West Region, abuse of office, delay in paying pension benefit, case under investigation. So what others have suggested is that this is wrong. What the law that sets up the OSP says in section 3.3, and if we may refer to it quickly so that you could respond to this question. Section 3.3 says, the office shall, on a half-yearly basis, publish the following information in at least 2 daily newspapers of national circulation and on the website of the office. A, the list of corruption cases investigated and prosecuted by the office. And B, the number of acquittals, convictions, and cases pending in respect of the cases prosecuted under paragraph A, and the value of proceeds recovered, if any.
I don't see where the breach of the law comes in at all. The statement in section 3 is the minimum requirement. In other words, twice every year, minimum, the office shall publish this list, all these lists. It doesn't say that the office beside these shall not publish any other, or shall not come out with any other publication. So what you have in the law is a statement of a minimum requirement. And therefore, a failure on the part of the office to publish this twice a year would be a breach of the law. But it doesn't, there's no exclusivity to it. In other words, there's no prohibition beyond this particular list.
Can they publish matters that have not already gone to court?
Again, the law doesn't state specifically whether the office can publish anything in a particular subject area.
It says the list of corruption cases investigated and prosecuted by the office and the number of acquittals, convictions, and cases pending in respect of the cases prosecuted under paragraph A, and the value of the proceeds.
In other words, what I'm saying is, what the law does is to give a minimum requirement of publication for offenses that are being investigated and prosecuted. But the law doesn't say that beyond these, there shall be no other publications. It is routine and it is standard practice that where an investigator or investigative body has been set up, the investigator or investigative body informs the public as a matter of public interest issues and subjects into which investigations have opened. So these are just opening of investigations. It is standard practice, and as I said, nothing in the law has stated that beside these specific requirements of publications that ought to be met, i.e. cases that have been investigated and cases that have gone to court, the law doesn't say that there shall be no other publication. So if, for example, the Office of the Special Prosecutor decides to even open a case of special interest, in other words, where the prosecutor, you're a person of interest, and they've opened a case of having an interest in you, there's nothing that prohibits them from informing the public that we want to do this. It is just a case of public communication. As I said, there's nothing in the law that says that the Office of the Special Prosecutor, beside these two requirements, cannot inform the public of any other investigation.
What is the purpose of the law then? What is the purpose of the law then when it provides and gives the specifics?
The law has
investigated and prosecuted. Tell us the status of acquittals and convictions, and then tell us the status or if there's any money.
The law is there for purposes of checking the special prosecutor himself or the office in ensuring that they deliver on their mandate and in ensuring that the country is kept abreast. So you're supposed to publish and inform the public of cases of investigations that are ongoing, the status, the difficulties, the challenges, etc. And then you're also supposed to inform us of acquittals and or convictions. The purpose is information. But the surplusage of information itself destroys nothing. And for me, anytime we're speaking to the law, we always have to ask the question of the policy, because laws are normally informed by policy. The surplusage of information doesn't destroy the law. The policy of the law is to ensure that the special prosecutor doesn't operate in a closet and doesn't keep things in his chest. And when people ask him questions, he says, don't worry, I'm working. The purpose of the law is to keep the country abreast. So that obligation stated in the law is good enough, and it is complemented or can be complemented by any publications.
When I did some of my takes on a crusade against the police making arrests and soups, and then, as it were, calling the press to take pictures of these, suspects and putting them out, I took a lot of inspiration from you, because you were clear that that was wrong. How is that different from somebody you are interested in investigating a matter against them and telling the whole world that we are going to investigate this person, or we are interested in that person? And how does that not feed into the public to sort of begin to defame the person even before?
These people are often stripped, sometimes close to naked. They are sometimes even the victims of some police brutality. Sometimes we see it. And the whole impression, the whole picture, the whole context of their being paraded on the screens often creates a sense of conviction, when in case they haven't. But again, many of the people who are normally actually taking pictures of, etc., and shown on our screens are persons who have been arrested in a swoop. Often they are taking pictures of and they are shown on the screens before a proper vetting is done as to who was just caught in the wrong place at the wrong time, who shouldn't have been in, etc. I could potentially be in one of those. You could potentially be in one of those.
And they
You could have
don't
just
come
been
back.
visited.
And they don't come
They
back.
don't come
when
back
they
to clear.
pursue you to say.
Those are the difficulties I have.
Yeah.
They don't come back to say, having vetted them, this person appears
So
to be
tell
just
us how
having the
different
wrong-
that is
the,
from this.
The difference is that in this particular case, there may have been a clear case of investigations having been opened into a particular person's matter. Now, when a person is declared a suspect, when a person is declared an accused person, when a person goes through the trial and ultimately is convicted and becomes a prisoner, these are various stages of the criminal process. A suspect is not an accused person. An accused person is not a convict. Unfortunately, a combination of illiteracy and our own circumstances creates some of those difficulties. So what I'm saying is, for purposes of public investigations and for purposes of the OSP's work, if he opens an investigation into a particular person's matter and it's announced, honestly, on the face of it, that is not an embarrassment.
Okay.
The fact that you are being investigated for something of itself is not an embarrassment. But we all know that in Ghana, once the announcement is made, it creates a certain sense that this person may or might have done something wrong. So, per the law, the point I'm making is he's supposed to publish circumstances of investigation. Now, unfortunately for the list that we have, some may not have been assigned investigators yet. But the argument I'm putting across is it still doesn't detract from the fact that he has the powers or may have the powers to even publish that, because the statement in the law is the minimum requirement. That in the minimum, he should publish cases being investigated and cases for which there are convictions. But there is nothing in the law, and I know you probably are relying on the legal rule of interpretation that says the express mention of one thing is an implicit omission of the other. I don't think that applies here. In this case, there's just a statement of a minimum.
Okay.
So it can be added on, and the
All right.
surplusage of information doesn't destroy much.
Okay, thank you very much. Yeah, Clara wants to say something briefly.
Yes, very
do that
briefly.
quickly. We
Yes. I think we have
will
to bear
go
in
to
mind
the
that
next
the
issue.
OSP office has denied, if I am correct, they have denied that that list is coming from them. So I
At
think
least through the chairperson.
through the chairperson, they have denied it. And I think it is critical. I
But he
think
said
that
it's authentic.
But
No.
my sources indicate that denial is of doubtful validity.
But to avoid that, I think that's where professionalism comes in. I don't think there can be there should just be announcements in the media that this person is doing A, B, C, D. I think that there should be proper reporting, which means that if you are going to give information, proceed. At least the law says two newspapers, they must have a website.
And on their website.
Yes, put the information on your website. So that when we go to your website, we know that this is authentic information. So that we don't have a situation where we have information in the media and then you come out and say, well, it's not coming from us. And yes, at
Indeed,
least we
there's
need to
one
avoid-
deputy minister
Yeah,
whose
need to
name is
avoid.
mentioned.
Yeah.
And he's indicating that he's never spoken or heard from the office.
That's
but
right.
now his name is out there.
Right.
He's a deputy minister for
Yes.
finance, and he's embarrassed.
Right.
And we need to balance that. There's some
But do you
discretion.
agree? Do you agree with Abochi that even whilst a petition has just come to the OSP, he has not done anything about it? He's not invited people. He's not brought them, or he has invited. Nobody has been heard yet, and that is included in the list for the purposes of the public.
I think there's a certain balancing act required. We need to balance the duty of the OSP and then balance the rights of people. So the discretion has to be exercised right, because the truth too is that we do not want to provide opportunity for people to be defamed or maligned. So if the information is coming out, it should be proper report.
Right.
So if the OSP...
We, the media, we are very difficult animals. You can't control us when it comes.
So
once
that's why
if
the
I
information
understand,
has to
again,
be
and
proper.
I agree, if I may be allowed, this is important.
It has to be
You know, I
proper.
agree with Clara on this. Even if it did not come from the OSP officially. Now that it has come, there must be an official reaction. Now, the official reaction should take into account the fact that these people have their names there.
I hear you.
So either it is expressly denied or it is confirmed, and if it is confirmed, a proper status briefing given of where things are. It's important because we have persons of eminent respect
I hear you.
who are in there. And I think that corruption involves people. I didn't have the chance on this, but let me just shift that in. Corruption involves people. Potentially, the accused persons of corruption are normally people of stature.
Yeah.
And because it is a perceptual offense, it's an offense which depends a lot on perception. And it's also because it is consensual in character. It is normally parties who agree to do that. Corruption is one of the very few consensual crimes. Usually crimes are one-sided. But corruption is normally the crime in which parties, the conspirators, of course, conspirators in character, they have to agree. So the point I'm making is because of all these consensual and perceptual aspects of corruption, when lists like this comes out, we can't ignore them for long. Otherwise, we may perpetuate a perception which may be difficult to erase if we wait too long.
Right.
I think there must be a quick reaction so that for persons who may have some restoration to their image, if there's a need to do that, that is done quickly before things get out of
And then moving forward, it should always be official. If
Right.
information is coming off, they should make sure it's a proper report and it comes through the professional, at least the official.
Except that you see, you
Re-
can't
record.
impose
Yeah,
that regime on
yeah,
us.
that's it.
That's
Unfortunately.
but when it comes out, then they have
I
to
hear
react
you.
to say officially
Well, the
whether
media
it's
who
correct
also
or not.
intercept
Why the
and intend to
coincidence?
publish will have to be guided how they go
Maybe
about it.
you have a point.
Yes,
there. A
okay.
certain sense of
Right.
responsibility.
Because we live in a society where the rumor only
Yeah.
is enough a conviction for many people.
I hear you.
You are accused. You are not even accused. You just heard it somewhere. Okay, and it's the end of the matter.
I think
And
you have
we know
really
that-
done
I
it.
think
We know that anybody
after
can file it.
I think
but
after
we
how
know
many
there's no
years
interview.
I think after how many years of benefiting from this, people like Kweku should spearhead. Forgive me for doing this publicly, but people like Kweku probably should spearhead creating a code of ethics or advising
On
the Ghana
interception.
on interception. I think he's benefited from it, so now he's moving on. He's about to retire from the benefits.
I hear you.
So that, because I think we've gotten to a point. I know I'm saying this, I can't mention some
All right.
things, but there's been leakages from sources and quarters
The
that
code of ethics you are referring to and asking him to advise
Yeah.
provides explicitly that the journalist should use plain means to procure the news and information. But there's nothing wrong
Interest.
if they have to use like Oku
Public
say,
interest,
subterfuge.
public
Yeah, public interest and public safety.
All right, we take a break,
Like your report.
and when we return, we should go back
I also
to
went for the report.
we should go back to Pram Pram. We should go back to Pram Pram and check what is going to happen. What is going to happen to the project there? 5,000 housing units supposed to be constructed, and out of which the amount voted for is 200 million United States dollars. That project, we have not done half the number. Have we done a quarter the number? And yet the amount remains the same, or even a little more than the total cost. We'll be right back.